Good morning, good afternoon, or good evening from wherever you're watching or listening. My name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information plenty of bad folks would rather you not have. Today, ladies and gentlemen, we'll provide another installment into our quasi-series on SCOTUS blunders. And today's installment is definitely going to be one of the more controversial, even though in the recent years it was overturned, which is kind of ironic because what you'll hear from a lot of individuals in the pretext or the bastardization of the pretext of Marbury versus Madison, if the U.S. Supreme Court, whatever their opinions are supreme or equal in authority to the U.S. Constitution, then how in the world could they be overturned? How in the world could they be revised and changed and made new? Well, anyway, without further ado, the SCOTUS blunder we'll be discussing today is none other than Roe v. Wade, in which the U.S. Supreme Court asked themselves this question: does the Constitution, the U.S. Constitution, recognize a woman's right to terminate pregnancy by abortion? Now, that's the actual question listed on oye.org, but the majority of the case, and the transcript of the case, revolves around this supposed idea that there is this implied right to privacy, which very well could be found in the U.S. Constitution in Articles maybe 9 and 10 to the Bill of Rights. But what we see in this case, as I'll show you, is the plaintiff didn't allude to Articles 9 and 10, at least didn't directly depend upon those two articles. Instead, she tried to suppose there was some sort of privacy right implied in the preceding articles in the Bill of Rights to the U.S. Constitution. So let's go ahead and jump on over to the case provided by OYE, or the case summary provided by oye.org. Roe v. Wade, it is settled in 1973. There it is. And we have the facts of the case. In 1970, Jane Roe, a fictional name used in court documents to protect the plaintiff's identity, filed a lawsuit against Henry Wade, the district attorney of Dallas County, Texas, where she resided, challenging a Texas law making abortion illegal except by a doctor's orders to save a woman's life. In her lawsuit, Roe alleged that the state laws were unconstitutionally vague and abridged her right of personal privacy, protected by the First, Fourth, maybe Fifth, and Ninth, and 14th Amendments. Well, we already know how we're going to address the 14th Amendment. The 14th Amendment was never ratified constitutionally. If you'd like more on that, we posted a lecture not too long ago. It's titled Addressing the Supremacy Clause in 14th Amendment. Very brief, very quick demonstration of how the 14th Amendment was not constitutionally ratified. Not according to us, but according to a federal official, a federal officer. So the Ninth Amendment, good of her to mention the Ninth Amendment. The question, as we said earlier, that the court ultimately was posed is, does the U.S. Constitution recognize a woman's right to terminate her pregnancy by abortion? Foreshadow, quick answer, no. It's nowhere near, explicitly or implicitly, nowhere near that intimate to the individual life, to getting involved at the individual citizen level. No, the U.S. Constitution in no way supports that. We have to remember the U.S. Constitution limits the U.S. government, not the states. In fact, there's only one part of the entire U.S. Constitution. It's Article 1, Section 9 or 10, which lists very few powers that the states don't get to practice as long as they are associated with the United States of America. So we come down to the conclusion, of course, the U.S. Supreme Court didn't think that way. Instead, they said inherent in the Due Process Clause of the 14th Amendment, so the argument's already gone because, again, the 14th Amendment was not ratified pursuant to Article 5 of the U.S. Constitution. Let's just pretend for spits and giggles that it was. The 14th Amendment is a fundamental right to privacy that protects a pregnant woman's choice whether to have an abortion. However, this right is balanced against the government's interest in protecting women's health and protecting, quote, the potentiality of human life. The Texas law challenged in this case violated this right. Justice Harry Blackmun delivered the opinion for the 7-2 majority of the court. Remember this phrase right here, the potentiality of human life, because you're going to see the majority opinion betray that standard within their argument in support of abortion, in support of a woman's supposed right to murder her child in the womb. First, the court considered whether the case was moot, concluding that it was not, and they considered that because before the court had made a decision, the plaintiff had already given birth to the child she wanted to have aborted. When the subject of litigation is, quote, capable of repetition yet evading review, a case need not be dismissed as moot. So because this is likely to come about in the future, we're not going to get rid of this. We're not going to throw this out for moot reasons. Pregnancy is a, quote, classic justification for a conclusion of non-mootness. The Due Process Clause of the 14th Amendment, throw that argument out, protects against state action the right to privacy. No, it doesn't. And a woman's right to choose to have an abortion falls within that right to privacy. No, it doesn't. Just because you murder someone in private does not mean, oh, well, now you're protected by this supposed 14th Amendment that was never ratified constitutionally. A state law that broadly prohibits abortion without respect to the state of pregnancy or other interests violates that right. But wait, if there's any potentiality of life, where'd that phrase go? The potentiality of human life, why wouldn't you just ban any restrictions or reject any restrictions on state law? Or go the opposite end. Let me finish that sentence. Why wouldn't the Supreme Court just ban any restrictions from state laws on abortion? Or go to the opposite end. Prohibit any and all abortions. Because the potentiality of human life starts at the moment of conception. A state law that broadly prohibits abortion without respect to the stage of pregnancy or other interests violates that right. No, it doesn't. Although the state has legitimate interests in protecting the health of pregnant women and the potentiality of human life, the relative weight of each of these interests varies over the course of pregnancy. No, it doesn't. Because the potentiality of human life begins at the moment of conception. And the law must account for this variability. In the first trimester, so here is where they betray that standard. In the first trimester of pregnancy, the state may not regulate the abortion decision. Why? There's still potentiality of human life in that first trimester. Only the pregnant woman and her attending physician can make that decision. In the second trimester, the state may impose regulations on abortion that are reasonably related to maternal health. Reasonably related. You can't define that. You can't reliably define reasonably. And to maternal health, how do you define health? Are we talking about physical health? Are we talking about mental health? Are we talking about quantifiable health or qualitative health? In the third trimester, once the fetus reaches the point of viability, so now it's not potentiality of human life, now it's viability, which in and of itself changes over time. A state may regulate abortions or prohibit them entirely so long as the laws contain exceptions for cases when abortion is necessary to save the life or health of the mother. Okay, Supreme Court, point anywhere in Article 3 to the U.S. Constitution that allows you to make this determination at all, even remotely implies it. Because it doesn't at all, not in any way, shape, or form. And the 14th Amendment, again, that argument's completely gone because it was never constitutionally ratified. I do want to show you a little bit further in this annotation of the case. Please go and read through the entire transcript. This annotation is a fair representation of what was discussed, but I just wanted to hit further how the Supreme Court betrays that potentiality of human life standard that they establish. So here we have a person may choose to have an abortion until a fetus becomes viable. So no longer potentiality of human life, viability. Two different standards that they're trying to force together, but they can't. Based on the right, well, if you're being intellectually honest, they can't, which they're choosing not to be. Based on the right to privacy contained in the Due Process Clause of the 14th Amendment, viability means the ability to live outside the womb, which usually happens between 24 and 28 weeks after conception. Facts. The law in Texas permitted abortion only in cases where the procedure was necessary to save the life of the mother. When Dallas resident Norma McCorvey found out that she was pregnant with her third child, she tried to falsely claim that she had been raped and then to obtain an illegal abortion. Just an outstanding character. Am I right? You got pregnant, then you go and lie about something tragic, believe all women, right? Me too. And then tried to break the law and murder the baby that was in her womb. Both of these efforts failed, and she sought the assistance of Linda Coffey and Sarah Weddington. By the way, good on the medical facility that denied her the procedure. Both of these efforts failed, and she sought the assistance of Linda Coffey and Sarah Weddington, who filed a claim using the alias Jane Roe for McCorvey. The other named party, Henry Wade, was the district attorney for Dallas County. McCorvey gave birth, so here's the reason they considered the moot argument. McCorvey gave birth to her child before the case was decided, but the district court ruled in her favor based on a concurrence in the 1965 Supreme Court decision of Griswold versus Connecticut, written by Justice Arthur Goldberg. This concurrence had found that there was a right to privacy based on the Ninth Amendment, which is a valid argument, as has good historical support. Ninth Amendment. You can also extrapolate the Fourth Amendment and say, or Article 4 to the Bill of Rights, and say that this would be something like an unreasonable search or seizure. It also says the people are secure in their persons. Now, we also have to remember that the Bill of Rights, again, limits the U.S. government, not the states. However, the district court refrained from issuing an injunction to prevent the state from enforcing the law, leaving the matter unresolved. Skip down a little bit further. So here's what the majority found. And it's kind of an elongated version of what we saw in that summary that was provided by Oye. So it says the majority found that strict scrutiny was appropriate when reviewing restrictions on abortion, since it is part of the fundamental right of privacy. Blackmun was uninterested in identifying the exact part of the Constitution, what a shocker, where the right of privacy can be found, although he noted that the court had previously located it in the 14th Amendment rather than the 9th Amendment. It's funny because the 14th Amendment wasn't ratified constitutionally, but the 9th was, or the 9th article. The opinion applied a controversial trimester framework to guide judges and lawmakers in balancing the mother's health against the viability of the fetus in any given situation. In the first trimester, the woman has the exclusive right to pursue an abortion, not subject to any state intervention. Any reason? Nope, none given. In the second trimester, the state cannot intervene unless her health is at risk. Any reason? Nope. Any constitutional basis? Nope. If the fetus becomes viable, once the pregnancy has progressed into the third trimester, the state may restrict the right to an abortion, but must always include an exception to any regulation that protects the health of the mother. Any constitutional basis? Nope. Any reason? Nope. Is there anything mystical or magical that happens between trimester 1 and 3? Nope. How about trimester 2 and 3? No. That potentiality of human life standard that they stated at the start begins the moment of conception. The court, which included no female justices at the time, that doesn't matter, appears to have been confused about the differences between the trimester framework and viability, which are not necessarily interchangeable. It is interesting to note that Blackmun was particularly invested in this case and in the opinion, since he had worked at the Mayo Clinic in Minnesota during the 1950s and researched the history of abortions there. This may explain why he framed the opinion largely in terms of protecting the right of physicians to practice medicine without state interference, by counseling women on whether to pursue abortions, rather than the right of women to bodily autonomy. Now that is a fair argument, one for the state courts to handle still, but that is a better argument than the manufactured one by the other judges. Why? Because that's a question of free market. A physician should be able to offer that service. Now, should the mother be able to partake in that service? No, because that's just murder. Now, if the third party consents to it, let the procedure begin. But there's no consent ever to be taken from the children in the womb. Caleb, that sounds extreme. It sounds extreme, but consider the opposite. If you don't allow a party to determine for themselves their fate, now you're advocating for the government to get intimately involved into direct that person how to behave. This principle is something called voluntas non fit injuriam. We talked about it a few months back. And what it means is if you volunteer for it, you can't claim an injury. So if, for example, for spits and giggles, let's say the child in the womb can give consent. It has the capacity to give consent. It knows exactly what's going to happen and it approves, then the procedure can be undertaken. But because one of the parties involved to this transaction, so you have the physician, you have the mother, and you have the child, because that third party doesn't consent to the transaction, to that contract, then it cannot be lawfully undertaken. There was no consent given. Thus, there's an injury to be claimed. Now I want to read to you the dissent, because it's along the same lines as I'm getting to. It says, while criticized, White criticized the majority's arbitrary choice of a rigid framework without any constitutional or other legal foundation to support it. He believed that this aggressive use of judicial power exceeded the court's appropriate role by taking away power that rested with state legislatures and essentially writing laws for them. What is that? Legislating from the bench. Tell me anywhere in Article 3 it even remotely implies that the U.S. Supreme Court can do what they did. It doesn't at all, ever, not even implicitly. White argued that the political process was the appropriate mechanism for seeking reform, rather than letting the court decide whether and when the mother should be a higher priority than the fetus. I do like the way that ends. Why does the rights of a woman, of the mother, trump the rights of the child? There's no basis for it. There's no historical grounding. There's no constitutional basis, absolutely certain, for such a position to be stated, let alone be opined by the U.S. Supreme Court. No basis whatsoever. So that needs to be the question asked. Not whether there's this supposed implied right to privacy when going about murdering an innocent citizen, but when and why the rights of one person trumps the rights of a completely innocent individual. There's no basis for that. And under this rule of law, under the presumed equal application of the law, that child is entitled to just as much right, just as much protection as the mother. Now, I'm going to predict, well, what about if the pregnancy endangers the life of the mother? We've addressed this in a previous lecture. I'll give a brief summary. Virtually every death that's caused by birth and delivery is something called postpartum hemorrhaging, which, per its name, can't be predicted because it happens after the fact. You have some variables that you can consider, but none of them reliably or dependably predict if postpartum hemorrhaging is going to take place. So, point being, virtually the only reason that death occurs from birth, it's something that realistically, reliably cannot be predicted. Thus, it cannot be prevented. Prevented is the best word for it. Case in point, the reason, among many, this particular precedence is such a significant blunder is not only, of course, it's another attempt by the SCOTUS to extend its powers far beyond its scope, but because it's one of the most asinine. It suggests that a woman, a mother, who went and lied about being raped and then went and tried to have an innocent human being murdered inside of her, that the rights of that woman are superior to the rights of an innocent child. And that in order to justify this, we're going to put arbitrary numbers, arbitrary timelines as to when that murder is legitimate and justified and when it's not. One of the most asinine SCOTUS blunders. One of the most abominable in the history of the U.S. Supreme Court. So if you have any questions about Roe v. Wade, maybe questions about the previous blunders we've discussed, or maybe there's a legal topic you'd like me to cover in a future lecture, go ahead and post those down in the comments, because the entire purpose of the Calhoun School of Law is to provide you with the necessary skills and information such as this to combat any sort of lawfare that will be waged against you, your loved ones, or your hard-earned property. So please, if you have any questions, go ahead and post them down in the comments. Excellent. So my name is Caleb Glick. I'm a lawyer here in the great state of Texas with the Calhoun School of Law to bring you a lot of information that plenty of bad folks would rather you not have. I hope you enjoyed this lecture, and if not, while you're down in the comments, go ahead and let me know how I can do better so I can best serve that purpose of helping you. I hope you'll have a wonderful day, and until I see y'all in the next lecture for the next topic, I bid you all farewell.